Mr. Aryeh Neier, thank you very much for joining our interview series. Let me start right away with the first question. As one of the most influential human rights defenders in modern history, you have stated that you are persuaded Israel is engaged in genocide in Gaza.
Yes.
How do you define genocide in this context under international law? And how do Netanyahu's increasingly populist authoritarian coalition policies, particularly regarding humanitarian aid, military conduct, and civilian protections, factor into your conclusion that the legal threshold has been crossed?
Well, as far as the legal definition of genocide is concerned, it is the 1948 Genocide Convention that defines the crime under international law. And the crime consists of destroying a national, racial, ethnic, or religious group in whole or in part. And the destruction can take place through direct killing, or it can take place through creating conditions of life that have the effect of killing a group that is national, racial, ethnic, or religious in whole or in part. And the attempt to commit genocide is a crime under international law in the same way that the actual commission of genocide is a crime under international law. So far as those who organize the effort, I'm less focused on the coalitions they may form. It seems to me that the guilty parties are those who actually have the authority and have the intent. And intent is the crucial factor under international law in defining the crime of genocide.
Right. You have linked your conclusion primarily to Israel's sustained obstruction of humanitarian aid. From a legal perspective, do you interpret starvation as a method of warfare here, as evidence of specific genocidal intent to destroy a population in whole or in part? To what extent does Netanyahu's populist nationalist rhetoric and reliance on far-right coalition partners signal deliberate policy intent rather than reckless disregard?
Well, again, I'm not concerned with the coalition that may be supporting Netanyahu. The issue is, do they exercise the authority which makes them guilty participants in the crime of genocide? Starvation as a practice in war is forbidden under the first protocol of the Geneva Conventions. It's absolutely prohibited, and those who act with intent to cause starvation are among those who should be considered to have participated in the commission of the crime of genocide. I would say that although I focus heavily on the denial of humanitarian assistance, including starvation, the denial of water, the denial of medical supplies to the population of Gaza, I would also include as part of the crime of genocide the use of disproportionate force by the Israeli government. The Israeli government used 900-kilogram bombs in its attacks in Gaza, particularly in the early months of the attack on Gaza. Bombs of that sort can kill people 200 meters away. They are utterly inappropriate for use in a crowded area such as Gaza. To the extent that they have a legitimate use in warfare, they could be used, for example, to destroy a naval base or to destroy a military factory that is producing a large amount of armor for the opposing forces. But using them in crowded urban areas inevitably means that a very large number of those people who will be killed are going to be civilians in that area. And that's what happened in Gaza. So the combination of the way in which the attacks took place in Gaza and the use of the denial of humanitarian assistance, including the denial of food, water, and medical supplies, in combination, seems to me to add up to the crime of genocide.
Right. Based on your experience at Human Rights Watch and the Open Society Foundations, which forms of evidence are most critical for establishing war crimes liability in Gaza? Convoy interdictions, caloric deprivation, bombing patterns, or policy directives?
All of the above are factors that can enter into the evidence. If there were to be a criminal trial in the International Criminal Court, there would have to be evidence showing what the defendants actually did. There would have to be people who would testify to show what they did. There would be an examination of any documents that are available. There would have to be testimony from observers who have to be present. The Israeli government has done as much as it could to limit the possibility of testimony. It has prevented international journalists from going into Gaza. It has prevented human rights groups from going into Gaza. And so the witnesses would probably have to be people from Gaza who experienced those crimes, and they might have to be some Israelis who are knowledgeable about what the practices were and who would testify before the International Criminal Court.
Right. Given the populist pressures within Netanyahu's coalition, which levels of command responsibility appear most salient? Cabinet-level policy decisions, directives from the defense establishment, or field-level operational orders? How should investigators document the causal link between strategic blockade policies, child malnutrition, and elevated civilian mortality?
I don't think one can specify in advance how a prosecution would take place. It would be up to the prosecutors as to what evidence they are able to find. If they can find military directives, they would use those military directives. But if they are not able to get hold of military directives, testimony from individuals who were present when decisions were made would be important. And if they are not able to do that, they'd have to look at the patterns of action by the people who committed the crimes. They'd have to look at what actions were taken, for example, to destroy the farms and the greenhouses in Gaza, which provided some of the food. They'd have to look at those who obstructed the trucks that were trying to deliver assistance. They would have to look at the orders that limited the number of trucks that were going into to Gaza. All of these would be factors. It's impossible to specify in advance what evidence the prosecutors would use.
Right. You once critiqued the UN Human Rights Council's bloc politics and selective scrutiny. How should advocates leverage UN mechanisms on Gaza while mitigating the reputational drag of perceived selectivity and ensuring even-handed standards?
The UN Human Rights Council is a political body. The various governments that serve on the Human Rights Council at any given moment have their own political interests. They often form blocs, and to some extent, those blocs protect the countries that are members of those blocs. So if one is dealing, for example, with the crimes that are committed in Sudan, there may be some African countries that have alliances with Sudan. There may be countries that get oil from Sudan. Those countries may be protective of the government of Sudan. If one is dealing with the crimes of Russia in Ukraine, there may be countries that were part of the former Soviet Union that still have alliances with Russia that would be protected. It's impossible to rely on the UN Human Rights Council as a neutral body that is able to make decisions on crucial human rights matters because of the alliances between various countries. One tries as much as possible to mitigate that factor, but one can't eliminate that factor.
Right. Having been a key advocate for the international criminal tribunals for the former Yugoslavia and Rwanda, how do you compare the feasibility of creating a similar ad hoc tribunal for Gaza versus relying on the International Criminal Court? What lessons from Bosnia and Rwanda are relevant here, and which pitfalls should be avoided?
Well, the reason it was possible to create the tribunals for the former Yugoslavia and for Rwanda is that the 5 permanent members of the United Nations Security Council all accepted the creation of those bodies. None of them exercised their veto power to prevent the creation of those bodies. Unfortunately, it is the case that if there were an attempt to create an ad hoc tribunal along the lines of the International Criminal Tribunal for the former Yugoslavia or the International Criminal Tribunal for Rwanda, the United States would certainly exercise its veto power to prevent the formation of such a body. So I don't think we can expect that there will ever be a special tribunal for Gaza. I think the International Criminal Court, which has not been subject to such a veto power, is the only possibility of criminal prosecution for the crimes that have taken place in Gaza.
Right. If Israel were to initiate domestic investigations into alleged violations, how should the ICC evaluate their credibility under complementarity rules? In the absence of genuine proceedings, should European states more aggressively invoke universal jurisdiction to pursue accountability?
Well, one could evaluate whether Israel is acting in good faith in prosecutions in the same way that one evaluates any other situation in which there could be prosecutions. That is there a genuine investigative process, and does the investigative process actually lead to indictments? If Israel were to claim that it is engaged in an investigation and then its performance does not inspire credibility, then I think the International Criminal Court should proceed on the basis that Israel is not doing what it should do, and therefore only the International Criminal Court is capable of bringing such a prosecution. I think that it's entirely possible that some European countries will at some point exercise universal jurisdiction with respect to crimes that have been committed in Gaza. It is likely that Israelis will travel to various European countries, that the countries that have condemned the crimes that are taking place in Gaza may become aware that somebody who was a military figure is traveling within the country, and in those circumstances, one could imagine that universal jurisdiction would take place. There have been, for example, a number of prosecutions in European countries of Syrian officials who traveled in different European countries, in Switzerland, for example, and Switzerland used universal jurisdiction to bring such persons to trial. I don't imagine that this would involve the highest level Israeli officials, the people who have the most significant level of responsibility for the crimes that have taken place in Gaza. But I think it could well happen that there will be such cases, and we won't know until it actually happens whether there will be such trials. There are a couple of organizations. There's an organization based in Switzerland, for example, called Trial, which specifically looks for such cases and tries to see that prosecutions should take place. And I don't know whether they're looking at any cases right now. They might be, they might not be. I think most of the Israeli officials who have a high level of responsibility for the crimes in Gaza are avoiding travel to European countries.
Right. You have noted that both the International Court of Justice and the ICC lack direct enforcement powers and rely on state cooperation. What realistic regional and transnational coalitions, in your view, could translate court rulings into tangible protection or material relief for civilians in Gaza?
I'm not sure that an international coalition could do that. I think the critical thing is to try to get a case before the International Criminal Court. The International Criminal Court has jurisdiction over individuals, not countries. And If one at some stage could get top officials who were responsible for the crimes in Gaza to the International Criminal Court, that would be the way to get some kind of accountability. When the wars in the former Yugoslavia took place, the officials who were responsible for major crimes did not imagine that they might appear before the International Criminal Tribunal for the former Yugoslavia. But eventually, Slobodan Milosevic was sent to the court by other officials in Serbia. Radovan Karadzic and Ratko Mladic were eventually captured and brought before the International Criminal Tribunal for the former Yugoslavia. It took many years. It may take many years in the case of Gaza, but it can't be ruled out. It is a possibility that over time there would be a political change in Israel, and that future leaders might be concerned to see that there is some kind of accountability. One doesn't know how this is going to develop.
Right. According to numerous expert assessments, the US administration may be violating both domestic and international law by supplying arms to Israel, despite documented restrictions on humanitarian aid to Gaza. Based on your experience with US accountability mechanisms, do you believe American officials could face future legal challenges under the Arms Export Control Act or under aiding and abetting doctrines in international law?
I think I would give the same answer to the question about whether Israeli officials might at some stage affect accountability, might eventually be held accountable. One doesn't know how matters will develop politically in the United States. It's not possible that the Trump administration would see to the prosecution of those who may be complicit in the genocide taking place in Gaza, but one doesn't know who the officials will be in the United States 10 years from now, 15 years from now, 20 years from now, and it's possible that at some stage in the future there might be a willingness to have American officials prosecuted. I don't say that it's likely, but it's possible.
Right. You have emphasized that evangelical Christian groups, rather than AIPAC, exert disproportionate influence on US policy toward Israel. How does this ideological alignment affect Washington's responses to ICJ and ICC proceedings?
Well, certain evangelical groups in the United States have managed to incorporate Israel and the prospects for Israel in their theology. And those groups are particularly strong in the South, in the United States. And so there is a strong Southern political bloc that is immensely supportive of Israel. A man who is part of that bloc is Mike Huckabee, a former governor of the state of Arkansas, who the Trump administration has designated as its ambassador to Israel. So placing somebody like that in a key diplomatic position is indicative both of the strength of that bloc within the United States and of the political difficulty in surmounting the activities of that bloc.
Right. You had warned that President Biden risks losing young voters over his handling of Gaza. To what extent do you see US domestic politics colliding with international humanitarian law, and could electoral considerations meaningfully shift US policy?
I think there has been a division, a generational division in the United States. Among other things, older members of the Jewish community in the United States have tended to be very supportive of Israel, whereas many younger Jews, such as those attending universities in the United States, are very often critical of the Israeli government's policies. I think that extends beyond the Jewish population in the United States. I think there is a generational gap that is quite wide. How that will play out, I can't tell. It may be a significant factor in years to come. It may not.
Right. In your work on sanctions and human rights, you have argued that targeted measures can drive behavioral change. In Gaza, which tools, such as asset freezes, travel bans, or conditionality on arms transfers, would be most effective in influencing policy without exacerbating civilian suffering? Looking at past cases such as Myanmar and South Africa, sanctions effectiveness often depends on timing and international coordination. What benchmarks should be used to assess whether external pressure is genuinely shaping Israel's policy on humanitarian access?
I think it's very difficult to answer that question. I would not have imagined before the sanctions were placed on South Africa what would be most effective. But I think that in the case of South Africa, for example, the international sports ban had a significant effect. South Africans are, like the people of many countries, very supportive of their athletes and very eager to see their athletes prevail in international competitions. And when South African athletes were excluded from international sports competitions, that had a significant effect. Economic sanctions also had a significant effect. My guess is that in the Israeli situation, the most significant kinds of sanctions would be those which impose limits on military support for Israel. Israel actually is itself a significant manufacturer of arms, and a lot of Israel's international revenue comes from the sale of arms to various countries. So that I think that if sanctions were imposed, they should be two kinds of sanctions. One, a sanction on delivery of weapons to Israel, and the other, a sanction on the purchase of Israeli weapons. I once talked to an Israeli official about limiting the sale of certain weapons to other countries which were engaged at that point in very serious human rights abuses. And what he told me was that in order for Israel's arms manufacturing to produce the weapons that Israel itself thinks it needs, Israel has to achieve economies of scale and has to manufacture a great many more weapons than it actually needs for its own purposes. And therefore, it has to be able to sell those weapons to other countries. And selling weapons to other countries, he said, was crucial for Israel's own military purposes. And my guess is that that's probably still the case. And so if sanctions involved refusing to purchase Israeli weapons, that might be as effective as actually refusing to sell certain weapons to Israel.
Right. As someone who defended free speech in the Skokie case, how do you distinguish between anti-Semitism and legitimate criticism of Israeli state policies, especially in today's polarized academic, civic, and political environments?
Well, differentiating anti-Semitism from anti-Israel speech is something that the Trump administration has failed to do. It has attacked many universities in the United States, accusing them of allowing anti-Semitism to flourish on their campuses. And very often, the protests that have taken place on American campuses are protests of Israeli practices rather than protests that have an anti-Semitic character. From a free speech standpoint, my view is that even anti-Semitism is protected speech. It isn't the case, however, that many universities in the United States are public universities where the First Amendment's free speech guarantees apply. Many of the universities that are accused of allowing anti-Semitism to take place on their campuses are private universities like Harvard University and Columbia University, and they don't have to adhere to First Amendment protections for freedom of speech. Nevertheless, in general, they do try to protect freedom of speech. I think they can protect freedom of speech even for anti-Semites, but they shouldn't allow those persons to disrupt university activities such as classes or graduations or other university activities. So one needs to look at each of those situations and see whether the university has acted appropriately. But the Trump administration, by confusing anti-Semitism and anti-Israel positions, has made the whole situation a mess.
Right. And lastly, looking ahead, what model of transitional justice would best address violations committed by all parties? A hybrid court, ICC-led prosecutions, or a regional truth and reconciliation commission with prosecutorial powers? How can victim-centered justice remain central in the face of deep political deadlock?
I think the only possibility of accountability is prosecutions before the International Criminal Court. I don't imagine that there would be a Truth and Reconciliation Commission that could function effectively because it would have to involve both the Israelis and the Palestinians. And it's very difficult to imagine that they would collaborate on a Truth and Reconciliation Commission. And a Truth and Reconciliation Commission would not itself have prosecutorial powers. In the case of the South African Truth and Reconciliation Commission, there was legislation which provided that those who did not disclose their crimes and acknowledge their crimes still could be prosecuted. But the prosecution was separate from the Truth and Reconciliation Commission itself. And in practice, not that many persons who had committed crimes during the apartheid regime were actually prosecuted in South Africa, even when they refused to acknowledge and disclose the crimes that they committed. So I'm not at all inclined to think that a Truth and Reconciliation Commission could play a useful role in the situation of Gaza. I think, as difficult as it may be, one should try to see to it that the International Criminal Court is able to function with respect to the crimes committed in Gaza.
Aryeh Neier, thank you very much for your time. Appreciate it.
Thank you. I'm glad to do it.